It's a major verdict from the Supreme Court. 15 death sentences have been commuted to life in prison. The court said that delays in deciding mercy petitions is a relevant ground for commuting death sentences. It also held that a convict must be hanged within 14 days after the dismissal of his mercy petition. The Supreme Court added another ground for dismissal of death sentences. It said that solitary confinement of a death convict or indeed any prisoner is unconstitutional. This verdict affects several people on death row, 15 of them to be precise. These include sandalwood smuggler Veerappan's aides. They've been on death row since 2004. It also included insanity and schizophrenia as valid grounds for commuting death sentences. Now, the delays in some of these cases in executing these men and women have ranged from 5 years to 13 years. Among those whose death sentence has also been affected is the Khalistani terrorist Devendrapal Singh Bhullard. Although he was not one of the petitioners, it will have an impact on his case since his plea was dismissed last year on the very same grounds that have now been admitted by the Supreme Court. The verdict will also have an impact on 3 men who've been sentenced to death in the Rajiv Gandhi assassination case. Jaskirat Singh Bawa has been tracking the verdict and is now with us on the phone, live from outside the Supreme Court. Jaskirat, a major decision. Break it down for viewers.
Absolutely, Pierre. Now, one has to understand that this judgment has effectively overruled the previous judgment of April last year, where Devendrapal Singh Bhullard's plea for commutation of the sentence to life sentence was dismissed. So that is effectively you could say it has been overruled. Now, what the Supreme Court has done today is the Chief Justice of India has said that inordinate and unreasonable delay, and in this case, we have seen a delay ranging from 6 years to over about 12 to 13 years. That amount of delay is it's a violation of Article 21, which is the right to life and personal liberty of the Constitution of India. It's a fundamental right, and that is a sufficient ground, and the Supreme Court is convinced it's a ground enough to commute death sentence into life sentence. Solitary confinement has been seen as an additional punishment, not authorized by law in all cases. It has been looked down upon by the Supreme Court today, especially solitary confinement of death row convicts. Insanity is also one of the major grounds that the Supreme Court relied on, and was convinced that at least in 2 of the cases that were the petitions that were filed, that the prisoner were in fact clinically insane or medically certified to be insane or mentally unfit, and that was also a ground for commutation of their sentence into life sentence. Now, all this effectively means indirectly Devendrapal Singh Bhullard and even Rajiv Gandhi's killers may have another shot at getting their sentences commuted to life at the Supreme Court. Devendrapal Singh Bhullard had filed a curative petition that has been kept pending for this particular judgment. So we have to see in written what really happens with his petition. Now, the Supreme Court has also issued guidelines, very importantly, which indicate that they feel that there were a lot of gaps which needed to be filled in the prison manuals with regards to the death row convicts. Amongst the major guidelines that have been issued or the guidelines that have been stated by the Chief Justice of India is the fact that the relatives and the prisoners themselves have to be kept constantly informed about the status of their mercy pleas, because they found that in many cases where mercy pleas are rejected by the governor or the president, the people who have filed the mercy pleas are not kept in the loop.
All right, just on that point that you were just making over there about prisoners' families not being informed, 2 cases come to mind, both of them from last year, involving convicted terrorists. Presumably, that's something that the court would have based its verdict on.
Absolutely, Pierre. Thanks for pointing that out, because that's a major takeaway today. Now, what effectively has been done in overruling the last April's judgment by Supreme Court today is that the distinction between Tata and non-Tata cases, which for a layman is terrorism-related cases, anti-national cases from a regular criminal case, that distinction has effectively been removed. The Chief Justice of India, heading the 3 judgment, in his judgment today, effectively said that.
I'm afraid I have to interrupt you. I'm afraid I have to interrupt you, but I will come back because we have Majid Memon, who's a senior lawyer, joining us on the phone line right now. Mr. Memon, your first reactions to this verdict?
You see, whenever a due process of law hands down a death sentence to a person who is found guilty of a heinous crime, and his execution is ordered by the court of law, then his execution must promptly take effect. If it does not take place for long years, that would mean that the convict is also undergoing imprisonment for that term, maybe 1 year, 2 years, 5 years, 10 years, which imprisonment was not the part of the sentence handed down by the court. So from this aspect also, tendency of execution amounts to violation of right of the convict A. B. Then these kinds of pendency of petitions are, pendency of executions are sometimes hazardous to the interest of society and to the state also. It is always desirable that the sentences awarded to offenders are executed without delay. With this spirit, and then secondly, the Supreme Court has expressed its anguish at the convicts being kept in solitary confinement for years together, which is again amounting to, as the Supreme Court says, cruelty, which again is not a part of sentence. So I think this judgment deserves to be appreciated and must be followed in days to come.
Mr. Memon, our reporter Jaskirat was informing us just a couple of minutes back that one of the important aspects of this judgment is that it no longer makes a distinction between terrorism cases, as he was saying, cases under the TADA or versus other criminal cases. The reason I'm asking this is because last year, during the executions of the two convicted terrorists, there was quite an uproar about the procedures that did not seem to have been followed, particularly the informing the families of these men before they were informed. The Supreme Court now saying that that must be done.
No, see, remember, it's difficult to draw hard and fast distinctions between different types of cases. Once a criminal trial takes place and culminates into finding of guilt of the rarest of rare crimes, it is only then that the death penalty is handed down. And once death penalty is handed down, naturally the procedure following the trial court's conviction right up to the appellate level and the President's mercy reconsideration is all that is uniform for every case. And therefore you can't have different methods, in terrorist cases or in other type cases, etc.
Mr. Memon, thank you for sharing your experience and thoughts with us on this major verdict. Jaskirat Singh Bawa is still standing by. Jaskirat, we had to interrupt you. I took the question to Majid Memon so I can come to you on another one. There are quite a few people on death row who've been affected by this verdict, some would say in a positive sense. Give viewers a sense of who some of these people are.
Absolutely, Pierre. Now, some of these people have actually been in the prison for almost more than a decade and a half. So I'll just quickly go through the list of people who are in fact affected by this, including Suresh Ramji, now Virappan's brother Gnan Prakash and his aides Simon Misik and his 3 other aides, Bilawendran, Praveen Kumar, Gurmeet Singh. There was a sensational case in Haryana involving a couple where the lady, the wife, had actually ended up killing her entire family. This would be Sonia and Sanjeev Kumar, Jafar Ali and Shibona. These are the names where the delay has been the reason for commuting the death sentence to life sentence. And if in the case of Sundar Singh, who is now in a prison in Uttarakhand, the reason for commutation was given as insanity was the ground that the Supreme Court considered. Now, these cases go from kidnapping, murder under which is considered the rarest of rare case when they were convicted. So the range of the crime committed by these people is actually quite varied. We also have people who were convicted for smuggling and murder and cases of TADA is actually under for people who were convicted for Rajiv Gandhi's assassination. Now, their plea was not there today in the Supreme Court. However, today's judgment does effectively indirectly impact their plea as well as Devinder Pal Singh Bhullar's curative petition, which is pending in the Supreme Court.